Yesterday we had Opposition Senator John Taylor. She lamented the fact that when people call for the death penalty, the issue is not that we don't have a death penalty. We have a death penalty. It's just that we can't seem to make use of the death penalty because they're on death row for way too long, and then at that point, based on the precedents, Pratt and Morgan,
yes,
can't execute them anymore.
Yes, the Privy Council ruled, however, how many years ago, more than 20 years ago, I believe, that you have to undertake the hanging or the death penalty within 5 years. And given our system, it's impracticable because, one, our system is generally slower, but then the persons on the convicted individuals have a right to appeal. And an appeal process is not something that happens overnight. So it seems that it just has not been possible.
In other jurisdictions, do appeals usually take so long?
I haven't taken an extensive look into other jurisdictions, but I'm not even sure that they even have those restrictions. First to begin with, many Western societies no longer have the death penalty on their books.
True.
I think the United States is one of the last, and it's only some of their states, right? So I don't even think they have those sort of restrictions that we have. We have those restrictions imposed by the Privy Council in the United Kingdom. So I don't even know if the time limit is really the important factor in relation to what restricts them from undertaking their death penalty.
Well, two things. First of all, we are a part of the Privy Council. We're not the Caribbean Court of Justice as the final appeal court.
As the final, yes.
But from what I understand, both courts seem to be anti-death penalty, if I'm not mistaken.
Well, yes, they're both anti-death penalty. The Privy Council did rule quite recently last year in the case of the State and J. Chandler that it is unconstitutional. The only difference between them is that the Privy Council is of the opinion, though we find it's unconstitutional, your country, well, Trinidad and Tobago in particular, we have something called the Savings Clause in the Constitution that preserves laws that were in effect prior to our independence. You have that savings clause, and that's what saves this clause, the death penalty clause. Whereas the CCJ is saying they have taken a different approach, which is, yes, savings clause, we understand that, but they have adopted what is called a modified approach to their interpretation of how the savings clause impacts things like the death penalty. And for that reason, they have been able to rule that mandatory death penalty is unconstitutional in countries that are under their jurisdiction.
So then precisely, even though the savings clause exists, precisely what is the point of us still having a death penalty on the books? It seems as though it makes absolutely no sense at all.
And I could see why you would say that, because the attorneys who represented the state in that case, J. Chandler and the state, admitted and agreed that the death penalty, the mandatory death penalty, was cruel and inhumane. But they are like, well, it's cruel and inhumane, but it's still on our books, so you can't strike it down as unconstitutional. So it seems that the state, through their representatives, have accepted that it's cruel, and that's probably, in addition to the 5-year limitation, that's probably a policy decision why we don't undertake the death penalty.
But is the issue that it's mandatory, that there's no leeway on sentencing so that you could give circumstances, treat them differently, because not all murder is going to be exactly the same. I would say the Pennywise ambush robbery, that gun down those, that's a whole different level of murder. It's some crime of passion where you get caught up in the moment.
Yes, exactly. Well, I don't even know if the discussion in Trinidad even gets to the point of discussing whether or not what we can do in relation to the fact that it's mandatory, but I think that's a very important point, because I support the death penalty in principle. Like, I have no problem. Hangings, probably we should undertake it in a more humane way, maybe lethal injection. Hanging, maybe not so much. But I don't have a problem with there being a death penalty in our books. My problem is that there's no discretion. A judge has no discretion to say, okay, well, you were a secondary to murders and you were not the person pulled the gun, you aided and abetted in some way, your liability or the circumstances of the matter, your culpability, your general conduct. There's no discretion. And that is my problem with our death penalty.
Why does it take so long for appeals to go through this court system? Why is it that it goes on for years, sometimes decades?
Well, that's a very good question. There's so many reasons why that is so. Depends on what you're appealing. Well, you might have never seen a grounds for appeal. Sometimes you can have 20 grounds for appeal.
Oh, Lord.
So there's a lot of legal discussions to be had. There may be some financial issues, and then the appeal, you have different international organizations you can appeal to. So there are different fora, there are different grounds. So there are many reasons that can affect how long an appeal takes.
Mm-hmm. But I think this situation is distressing and disturbing because the businessmen across TNT, I mean, yes, every citizen is very much living in fear. And I will never downplay that. I also think that businessmen calling for the hangman to return. I mean, the hangman never left. He's just on paid leave right now. You know,
I don't know if he's on paid leave.
No. He's a public servant, which means he gets to collect a check.
Perhaps his job spec has been modified by now. Surely.
But here's the $1 million question, because what the senator kind of left unanswered, and I think it's an unspoken, implied question. People blame the government, and she's like, well, no, the death penalty is on the books. And it has implementation problems. However, can't it be modified via new legislation, to try to get something that's more workable and practical? For instance, maybe taking out the mandatory part. So now the court rulings that are putting this constraint might have to be, well, we might need a new ruling. They might have to settle it with a new case. But we could get something more practical, because people basically go to that. It's like low-hanging fruit. And so far, the politicians kind of get away with the excuse, well, we have a death penalty in the books, but we're not actually trying to work anything with it.
Well, the Privy Council has basically said that in their approach. They find it cruel and inhumane, but they saying they cannot declare it unconstitutional because it's on the books. So they're saying it's really up to Parliament as the democratic body with that portfolio to make the amendments. But I heard the argument that if we were to try to change it now, and after we have achieved independence and everything, they again will bring a case that how can we now institute a law that has been accepted as cruel and inhumane? So there's basically any modification would still fall under being cruel and inhumane.
Well, it's not the exact same law. So now what, again, if mandatory is part of the thing.
Mandatory is part of the problem.
That makes it right. We're taking that out. Now we're going to the part where separation of powers is kind of coming into question, because you're telling elected officials, who to some extent we could argue might be listening to the will of the people, what they can and cannot do in a different jurisdiction.
But you made a point about low-hanging fruit, and I think that's a point that when I think about this whole argument, all the time we are calling for the death penalty. To me, the death penalty is literally and figuratively the final nail in the coffin. People are saying, let's impose the death penalty because it's a clear signal to criminals. It's a strong avenue for deterrence. But studies apparently have shown that having a death penalty or utilizing it is not an appropriate form of deterrence. I don't know about that, but my
not effective.
Not effective. But my problem, whether or not we argue whether or not it's effective, is that there's so many things that need to be addressed before that are, to me, more important and more pressing in terms of deterrence. Firstly, our detection rate.
Yeah, that is right.
The mandatory death penalty only applies to murder. Not all serious crime, it only applies to murder. Our detection rate for murder is 13%. That's one. Then it takes forever to even prosecute the case. That's two. If we had we had better detection and a more efficient system for prosecuting someone, and they know whether or not they would be hanged, let's say they were going to get life in prison, and they're seeing it happening, that might be just as effective as a deterrent.
Well, one point before I go to my final question. Yes, studies suggest that it may not be an effective form of a deterrent. But at the same time, I think how people are thinking is, I rather see an individual who has been convicted and found guilty of a crime. I've heard people say arguments that even if they're found guilty in the courts, you're still not absolutely sure that this is the individual. We've seen people who have been in prison for 30 years coming out and saying, the case was thrown out because somebody confessed to the crimes. So that has happened.
That's the other problem.
But people have also suggested, I rather an individual who's found guilty of a crime to be executed, because I don't want to pay for them to sit in a prison for 30 plus years. Prisons are run on taxpayers' dollars. So that is one argument as well. That money could be utilized elsewhere. But, this thing about Earl Pratt and Ivan Morgan, that particular case, it's Commonwealth law, if I'm not mistaken. Is Trinidad and Tobago, though we are part of the Commonwealth, are we obligated to follow such laws on judgments?
The judgment was from the Privy Council, which is our final
Right.
court of appeals. So yes, we have to.
In this case, yes. It's not
Yes.
a treaty that we're following. It's our actual law.
It's the law. Case law is law. And the case under the judgment is clear, 5 years, or you can't do it. And we have to adhere to that unless there's another ruling I don't see happening.
To a certain extent, you can have a government drafting legislation and it being declared and whatnot, but then you also have the courts where that separation lies. If they give their ruling, that applies to us as well. Do you understand?
Because the court can rule something as being unconstitutional.
Yeah.
And then essentially mandate you. Well, we have said it's unconstitutional, you really have to change it.
We shouldn't look at the Privy Court as a foreign court. We have it by our own law as our final
It's a
court.
foreign court, but we have agreed, and that's another argument for another day. Why have we not gone over to the CCJ?
Which technically would also be another somewhat
But the
foreign
CCJ
court.
wouldn't be a foreign court because, one, it's a court made up of judges from the Caribbean, including Trinidadian judges, and they would be, and the argument is, they are culturally more close to us than a judge in the United Kingdom.
And apart from that, I don't know if you recall, but we argued.
Yes,
The
I know.
CCJ is based in Trinidad, you know.
We argued and fought for the CCJ to be in Trinidad.
I know. I had like a almost decade gap between when I started my first degree and when I finished it, and I had because Roytech is next to the CCJ, so
Right, exactly.
so one of the legal lecturers there, he's basically like, yeah, and we argued for it here,
Right.
and we're probably not gonna be in it, and then almost a decade later, we're still not in it, and I was like,
So-
yeah, I was there when you started this part of the course.
That's like having the OECS headquarters in Ghana, right? It just doesn't make sense sometimes. But anyway, we have to take a break. We have to take a break.
Just one last quick observation, though. What about the fact that, yes, you could give them life in prison, but they could still communicate with the outside world for all intents and purposes. We've seen, I think, not too long ago, a prison guard was detained because he was trying to smuggle in contraband, which I think included cell phones. I'm not too sure. So
I was like, what is the question, Sean?
So my
What
thing
is
is,
the question?
my thing is, and maybe this is just a statement, I don't know if you'll agree with this, there will be some criminals who, life imprisonment isn't really stopping them from continuing their life of crime, and maybe you need some, because life in isolation might be cruel and unusual as
I
well.
was going to say, Sean, we just went through a pandemic where a lot of us there was a curfew and we were isolated indoors. Yes, we had phones and we had other ways of communicating and people were still going crazy. So don't undermine or overlook the punishment involved in just having to be confined to a particular space.
That's for normal
Lady
people.
and
but
gentlemen,
criminals are not normal people.
I am putting my foot down. Finally, we can take our break that is intended to be taken at this time.